Hello everyone, welcome to Commerce and Management classes. Today in this video lecture, we will be discussing about nature of contract and introduction. Before we get into this video, I would like to express my heartfelt gratitude to all my subscribers and viewers of my YouTube channel. So let us start with a small story about a business law. So here there is a story of Rana Minno's vibrant red market, I mean the chili market. So Rana Minno is in the North Karnataka, and we have got Mr. Basuraj, who is a respected Bandy chili farmer and who is also a local trader in that particular region. And we have also got Mr. Rohit, who is a spice merchant who is from Hubli. So there was a deal between them. So the deal is for the entire harvest season of the crop that is grown by Mr. Basuraj, and the deal amount is rupees 1 lakh for your 6 quintals of chilies. So there was an agreement between Mr. Basuraj and Mr. Rohit, and that agreement was marked by the traditional exchange of betel leaves and arecanut, which is the tradition of that particular region. But the unfortunateness or the impossibility is that after the few days of that agreement, there was a sudden pest attack or insects attack and destroyed the entire crop, which puts Mr. Basuraj in a helpless position. And Basuraj told the same story to Mr. Rohit with a long face and a worried look on him. And betrayed and frustrated by the situation, Mr. Rohit said that he needed chilies badly to sell to his customers who were relying on his masala powder, and he demanded a compensation of rupees 1 lakh. So there was an argument between Basuraj and Mr. Rohit. Looking at this scenario, the elder and experienced person from Gram Panchayat came, that is Mr. Party, and he explained the frustration of the contract and also the impossibility of the contract. And he said that the pest infection was not in the hands of Mr. Basuraj, it is out of the control in the hands of Mr. Basuraj. So therefore, they have to reach to the middle ground, the common ground where both the parties should gain from each other because of this impossibility of the performance of the contract. Therefore, to preserve the market goodwill, both of the parties have reached a common ground, telling that Basuraj is still left with some quantities of chilies and Mr. Rohit still needs a little bit of chili powder to make a blend to his masala powder, and he could he could sell those remaining items to the customers. Therefore, Mr. Rohit acknowledged and agreed the impact of impossible nature of the contract and also appreciated the wisdom of Mr. Patil, and all the traders and the local traders in that APMC market said Jai Malarlinga. So the contracts sometimes becomes impossible to perform, and we could well see that there are so many things done here. There was a promise between Basuraj and Mr. Rohit. There was an agreement between the two parties, and they've agreed upon the same thing in the same sense. But due to the impossibility to perform because of the unexpected thing happened, so we could see that they have to reach to the common ground. So these kind of things does happen in the business scenario. Mr. Basuraj found himself in a difficult situation, and Mr. Patil could resolve the issue because he knew about the law and the legal framework. Therefore, the business law is so much important to understand and learn and do the necessary things. Now we will have a talk about the law of contract. So the law of contract is the most important branch and also the basis for other branches of the mercantile law. It is the foundation on which the superstructure of the modern business is built. Business law does not only affect the businessmen but also the common people. Why? Because the promises are made at one particular point of time in the businesses, and the performance are done at the different points of time and the different time intervals. So in order to be able to perform the promise, these laws are very much crucial. Why? Because if you promise and if you don't have any intention of performing it, it will cause a harm or an injury to the other person who believed it to be true. Therefore, to check and to have a restriction, to have a legal enforceability, so whenever a person makes a promise, he must carry the intention of performing it. So in order to be able to complete that chain of work nature, so promises have to be performed. So there is a law in place that is named perfectly as Indian Contract Act. So what does contract mean? So that we will discuss in a little while. So here I've written contract is equal to agreement plus legal enforceability. So earlier promise, and the promise will be between the two parties, and then performance. So promise and having an intention of performance will be a contract. So what is contract? Contract is an agreement between two parties in which is legally enforceable. Now we will talk how the Indian Contract Act came into force. So with effect from the 1st September 1872, Indian Contract actually came into force in our country, which is largely based on the English common law, which is made up of judicial procedures, and it extends to the whole of India except the state of Jammu and Kashmir. So we will now see the important sections of the Indian Contract Act 1872, which came into force on 1st September 1872. So here I've given a table of sections and description. You could see that the definition of the basic terms like offer, acceptance, and all these terms contained in the section 10 and 11. And as far as free consent is concerned, which is an essential element of the valid contract, is contained in sections 13 to 22. And the legality of object and consideration, nothing but legal object, is contained in section 23 of the Indian Contract Act 1872. And breach of contract, one more important part of the Contract Act, which is contained in section 39 and section 73 to 75. Next, coming to contracts of indemnity and guarantee, which is contained in section 124 and 126 of the Indian Contract Act, and contracts of bailment and pledge is contained in section 148 and 172. And the quasi contract, which are famously known as constructive contracts, is contained in section 68 to 72. And contracts of agency is contained in sections 182 to 238. So earlier, the Sale of Goods and Partnership Acts were part of the Indian Contract Act, which were contained in section 76 to 123, which is a sale of goods, and the partnership agreements were contained in section 239 and 266. So these of goods sections repealed and made a new act in the year 1930, that is Sale of Goods Act 1930, and the sections from 239 to 266 repealed from the Indian Contract Act, and also made a separate act in the name Indian Partnership Act 1932. Having been discussed about the important provisions of the Indian Contract Act 1872 and its related sections, now we will move on to the definition of the contract. So what does contract means? So as per section 2 subsection H of the Indian Contract Act of 1872, contract is an agreement enforceable by law. So I was about to say that contract is an agreement between the two parties, but the section tells a little differently. That is agreement which is enforceable by law. And in the words of Salman, so a contract is an agreement creating and defining obligation between the parties. So from these two definitions, or the analysis of these two definitions, would give us a clear indication that contract is equal to agreement plus legal enforceability. So there the question arises, what is an agreement? Again, in the Indian Contract Act of 1872, from section 2 subsection E, agreement means every promise and every set of promises forming consideration for each other could be called as an agreement. So promise is happening, the set of promises is happening, and that is defined as an agreement in the section 2 subsection E of the Indian Contract Act. Again, the question arises, what is promise? Then the section 2 subsection B defines the promise as, or the means, when the person to whom proposal is made and signifies his assent thereto, the proposal is said to be accepted. When the proposal is accepted, becomes a promise. So therefore, we could again make out from this promise definition is that the agreement consists of two important things. That is, one is plurality of persons, the other one is consensus ad idem. So as per this definition, the plurality of persons is very much important. So what is this plurality of persons? What means one person cannot enter into an agreement with oneself. For example, Mr. X cannot enter into an agreement with himself. He has to reach to someone else. In the same manner, Mr. Y cannot transact with himself. So therefore, he has to reach another person. Therefore, an agreement between Mr. X and Y could be termed as plurality of person. Means there must be at least two parties to form a valid contract. And what is this consensus addendum? So consensus addendum is agreeing in the same thing, in the same sense, and at the same time. Means both the parties should not have any kind of confusion or ambiguity as far as the subject matter is concerned, subject matter of the agreement is concerned. They have to agree in the same thing, in the same sense. So we could well argue the fact that contract is an agreement between the two parties which is legally enforceable, and both the parties will be having an obligation. So what does agreement mean? Agreement means every promise or every set of promises forming consideration for each other. Then what is promise? As per section 2 subsection B, promise means the person to whom the proposal is made signifies his assent thereto, and the proposal is said to be accepted. When the proposal is accepted, it becomes a promise. And also we've learned that there must be at least two parties to form a valid contract, and both the parties must agree in the same thing and with the same sense. Now we will talk about the legal enforceability. So here, the legal enforceability gives a rise to the legal obligation. If the business agreements lacks the intention to create a legal relationship between the parties, then there will be no contracts. If there is no legal obligation, no contract. For example, the contracts of social nature, or the contracts of moral nature, or the contracts of realization nature lack the intention of creating the legal relationship between the parties. For example, if you are inviting your friend for a dinner party or the birthday party, and if he did not turn out on the given day, you can't file a case against him. And if you are calling him for any religious function or social function on any particular day, even though he agreed that he is gonna come or she is gonna come, and if he or she fails to come on that particular day, you can't file a case against them. Why? Because those kind of agreements lacks the intention to create the legal relationship between the parties. But the business agreements are not like that. So they have the power to create the legal obligation, and hence there is an intention to create legal relationship between the two parties. So failure to perform the promise will render a serious action. So here, if a contract gives a legal obligation, so you can come out of the contract by two ways. That is, by performance, the contract is discharged, means both the parties are free from the contract and its obligation. And if somebody will fail to perform their part of the promise, they're gonna face some serious legal actions or the consequences. Therefore, that intention to create a legal relationship is so much important in order to constitute a valid contract. Therefore, you could say or argue well the fact that all contracts are agreements. Yes, all contracts are essentially agreements, but all agreements are not contract. Why? Because agreement can be sometimes legal or sometimes illegal, or sometimes cannot be enforceable. Just like we have given an agreement to attend the birthday party or agreement to come to the dinner party. So these are all the things which lack the legal intention. Sometimes the agreements may be of illegal nature, or agreements may be of impossible to perform, agreements may be of uncertain. So these are all the things could not be called as a contract. Therefore, all contracts are agreements, but all agreements are not contract. This is all from this today's video lecture of the Indian Contract Act, an introduction, and the different provisions and its particular sections, and also the definition of the contract, agreement, promise, and legal enforceability. Thanks for watching. Please watch it and share it and subscribe it. Tell to your friends, and don't miss to hit the bell icon. And if at all you guys or in need of any topic of the commerce and management, I will be trying to attend those kind of videos as well. And in that case, you are most welcome. Thank you. Thank you very much.